Greetings, Attorney Derek DeBrosse here, Attorney Derek DeBrosse, Munitions Group, munitionsgroup.com. Look us up. Make sure you follow us on social media, click that little bell icon, and make sure you subscribe to our channel. We'll keep the topics coming. I believe Michael was just on earlier in the week, and he discussed the Chevron deference issues that were before the Supreme Court. So I hope you guys got to tune into that. Today we're going to be talking about juveniles and firearms law. So I did a little bit of digging on this, kind of find out what the status is around the country. I get questions on this a lot, you know. Can my nephew Johnny, who's 15, possess this handgun that Grandpa left him before he died? And it's an interesting question across the country, and it's a little bit different in every state. So let's kind of dive right in. I want to first start by talking about my home state, and that's Ohio. I think Ohio's a little bit odd in some ways and not so odd in others, but this is under Revised Code 2923.21. And this is entitled Improperly Furnishing Firearms to a Minor. So basically, what the law says is that no person shall sell any firearm to a person who's under the age of 18. So it's any gun at all. It's illegal to sell. Right? So that doesn't really answer the question, can someone under 18 possess? But it is illegal for somebody in Ohio to sell a firearm, any firearm, rifle or handgun, to somebody who's under 18. And then subject to Division B of this section, sell any handgun. So now we're just talking about handguns to a person who's under 21. So if they're 18 or 19, you still can't sell them a handgun, even though they could purchase a rifle. So you can't sell a handgun to anybody over the age of 21. And actually it says sell. So it doesn't say furnish or transfer, it actually says sell. And then number 3 says furnish any firearm to a person who's under 18, subject to Division B, furnish any handgun to a person who's under 21 years of age, except for lawful hunting, sporting, or educational purposes, including but not limited to instruction in firearm safety, care handling, or marksmanship. And here's the kicker: under the supervision or control of a responsible adult. They do not define responsible adult, but that's what the law says. So you might be wondering what Section B says, and basically what it says is that this section doesn't apply to furnishing a handgun to a person 18 years or older, or under 21 years of age, if the person's 18 years at least, but under 21 if it's for a law enforcement officer who's obviously properly appointed to an agency and trained by the Ohio Peace Officer Training Academy. Let's see here. And then also does not apply to the sale or furnishing of a handgun to any active duty member of the armed forces who has received firearms training that meets or exceeds the training requirements in the Concealed Carry Code. So there you have it. There's a couple other things here that it does forbid. You sell or furnish firearm to a person who's under 18 if they know or has reason to believe they're purchasing or receiving the firearm and they're in violation of A1 for the purposes of furnishing the firearm in violation of A3 of this section. So again, it comes down to, in Ohio, you can't sell or transfer a firearm to anybody unless it's for a legitimate purpose, such as education with a responsible adult there. Handguns if they're under 21, any other firearm under the age of 18. So what I get a lot is actually people will think, well, it just means they can't possess. I actually had a case years ago. I did a lot of juvenile law when I was a young lawyer, and I had a gentleman who was, I think he, at the time, when I first started representing him, might have been 17, but as the case proceeded, he ended up becoming 18. I don't think that was overly relevant, but nevertheless, he was under 21. During the pendency of the case, he was found with a handgun, and I remember the detective wanting to talk to me. Obviously, we didn't give him any information on where he got it, but he couldn't bring a charge because it's not illegal for him to have the gun. What's illegal is that transfer, right? That act of going out and trying to buy a gun as a juvenile, or the act of selling a gun to a juvenile and not doing a background check or finding out what their age is, rather. So that is actually what is illegal in Ohio. So the possession itself, I couldn't find anything in the code, never have in my career, that would deem it illegal. I always use the extreme example: if Johnny's 15 and Grandpa dies, they live in Tennessee at the time, and it's let's say hypothetically at least, it's legal for him to inherit the handgun from Grandpa in Tennessee. He acquires it legally in Tennessee, but then moves to Ohio. There's no crime committed. No one's transferred him a handgun within the jurisdiction of Ohio. He's legally allowed to possess that handgun. All right, so I want to go on from there. Let's talk about federal law. People think there's the same requirements under federal law that, hey, if you're a juvenile, you can't possess a gun. That's not what the law actually says. So what we're actually going to do is go now to the Gun Control Act of 1968, and this is found at 18 U.S.C. Section 922. And we're going to look at subsection B as in Bravo and X as in X-ray. And let's start with subsection X. And what it says is that it shall be unlawful for a person to sell, deliver, or otherwise transfer to a person who the transfer or the person giving the item knows or has reasonable cause to believe is a juvenile. So again, if you're trying to transfer a gun to a juvenile, that is what's illegal if it's a handgun or ammunition that is suitable for use only in a handgun. So again, it shall be unlawful for a person to sell, deliver, or otherwise transfer to a person who the transfer knows or has reasonable cause to believe is a juvenile. It's interesting. I haven't really done a ton of research into how this has been enforced. I would imagine that for federal law to even attach, that gun would have to be proven to have, worked its way through interstate commerce. Otherwise, it would be a states-only issue. So something to keep in mind. But that jives with Ohio law. So even if this isn't applicable, Ohio law would be applicable. It also says it shall be unlawful for any person who is a juvenile to knowingly possess a handgun. So that's interesting. I've never had this kind of case come across my desk, but this is I'm reading the law verbatim. This is what it actually says, and it also includes ammunition that's suitable for use only in a handgun. Then it goes on and it has some exceptions to that. If it's in accordance with state or local law. So even if it's illegal under federal law, if it's in accordance with state law, it doesn't apply. So in Ohio, again, you can possess a handgun or ammunition for a handgun as a juvenile. It's not the possession that's illegal, but if it's in accordance with state law, it says this subsection does not apply to, and it says right here, in accordance with state and local law. Actually, I misstated that. Let me read this a little more carefully for you guys. I apologize. It says this subsection does not apply to a temporary transfer of handgun or ammunition to a juvenile or to the possession or use of a handgun or ammunition by a juvenile if the handgun and ammunition are possessed and used by the juvenile in accordance with state and local law. So I just wanted to make sure that we got the breadth of that exception there correctly cited. So that's under subsection X. Let's look at subsection B that also talks about age restrictions. And under subsection B, it's B1, and I think B2 apply too. It says that it shall be unlawful for any licensed importer, manufacturer, dealer, or collector to sell or deliver any firearm or ammunition to any individual who the licensee knows or has reasonable cause to believe is less than 18, and if the firearm is other than a shotgun rifle or ammunition for a shotgun rifle, so again a handgun, to an individual who the licensee knows or has reasonable cause to believe is less than 21, and any firearm to any person in any state where the purchaser or where the purchase or possession by such person of such firearm would be in violation of state law. So basically, the federal law government says, hey, if you're a licensed dealer, importer, manufacturer, whatever it may be, you can't sell or transfer to under 18 for any gun, under 21 for handguns. And you also can't transfer the gun if state law prohibits it. And then it says no person, regardless if they're licensed, can transfer these items to juveniles as well, unless state law permits it. So that's where we're at with federal law. And now I want to turn to a couple other states because, like I said at the beginning, states are all over the place on this. And, we've talked about federal law, but for instance, long guns, a lot of us in Ohio at least might think, well, you're a long gun, you can buy it when you're 18. That's not true in a lot of states. California, Delaware State, Florida. I'm going to talk about Florida here in a minute, surprisingly enough. They're trying to change that. Hawaii, Illinois, it's the common cast of characters, right? Let's see here. I got some notes here. New York, of course. Rhode Island, not surprising. Vermont, again, somewhat not surprising. Vermont's an interesting state. We should probably do a video on them at some point in the future. Washington State. So it's common cast of characters, generally have a disrespect for the Second Amendment. These states have these age restrictions. Florida is the anomaly. So let's talk about Florida for a minute. And what Florida actually says in the law, and this is a relatively new law. I got a note here. Let's see, when was that passed? I think it was in 2018, actually, because it was right after the Marjorie Stoneman Douglas High School shooting that this took effect. And what it says is, I'm going to read it verbatim to you right out of the code. It's Florida statute, if you guys want to follow along with me. 790.065, sale or delivery of firearms. I'm looking at subsection 13. It says a person younger than 21 may not purchase a firearm, period. A person who violates this is a third-degree felon, and it's punishable, and it goes on from there. So it's very clear. If you're under 21, you can't purchase a firearm. That's the current law. I did find an article that talked about several representatives that have proposed a law to basically back that up and rescind that law, if you will, and lower it to 18 again. We'll see what happens. Not really sure what's going to happen, but that's where the status is in Florida. Washington State, at the same time, in 2018, also passed their own law regarding age limits, and it states that a person under 21 may not purchase a pistol or semi-automatic, what they term assault rifle. There are certain exceptions to that we don't need to go into today. So just, again, a taste of what we're dealing with. Now, Florida's law was, in fact, challenged, and the 11th Circuit Court of Appeals did uphold that as being constitutional. So now I want to turn to a federal case out of Virginia. That is Frazier versus ATF. And what the Frazier case basically said, there was four plaintiffs, 4 men. They were between 18 and 20, so under 21, but at least 18. One of them, Mr. Frazier, tried to go and buy a handgun. I think it was a Glock 19X, if I remember correctly. And he got denied, obviously, because he's not 21. So they were directly challenging the 18 U.S.C. 922 subsection B and X statutes, right, that this should be able to be done. And anyhow, so they filed this lawsuit. They're not otherwise disqualified from possessing or owning guns, and the court entered into a Bruin analysis, as they should have, right? Amongst other things that the judge stated, he also stated that, the right under the Second Amendment to keep and bear arms also includes the right to purchase firearms. The defendants, the government in this case, tried to make an argument otherwise. They also tried to attack standing, saying, oh, he can buy it privately and all these other things. And the court saw right through this and no, they're standing. And finally ruled on summary judgment, which is a procedural mechanism we use as civil litigators to say, look, court, facts are not in dispute. They're clearly under 21, clearly over 18, clearly allowed to otherwise have guns. Take the facts, apply them to the law. And the court did and said this is unconstitutional. That ruling has been stayed pending appeal. And as of, I think, October of last year, 2023, so a few months ago, the notice of appeal was filed, and that's kind of where it's, I believe, at right now. So that's kind of what we have. That's the landscape of juveniles and gun possession. I hope this was somewhat informative, but right now, again, if you're under 21, it's going to be difficult for you to obtain a handgun until you are 21, and if you're under 18, it'll be difficult for you to obtain any firearm the way the law currently stands. But remember, every state's a little bit different, and keep your eyes on that Frazier case. As always, remember to be safe and carry on.